Section 21. General Prohibitions. The Minister may by notice in the Gazette declare that no employer shall require or permit any employee belonging to a category of employees specified in the notice to perform work on or in any premises on or in which an activity specified in the notice is carried out, which is, in the opinion of the Minister, is an activity which threatens or is likely to threaten the health and safety of an employee belonging to that category of employees, or that no employer shall require or permit any such employee to perform any work on or in such premises otherwise than on the conditions specified in the notice. That no employer shall require or permit any employee to perform any work in connection with the carrying out of a process specified in the notice, which is, in the opinion of the Minister, is a process which threatens or is likely to threaten the health or safety of any employee, or that no employer shall require or permit an employee to perform any work in connection with the carrying out of such a process otherwise than on the conditions specified in the notice, and that no employer shall require or permit any employee otherwise than on the conditions specified in the notice to perform any work on or in any premises where an article or substance specified in the notice is produced, processed, used, handled, stored, or transported, which in the opinion of the Minister is an article or substance which threatens or is likely to threaten the health or safety of an employee. The Minister shall, before he publishes a notice under subsection 1, cause a draft of his proposed notice to be published in the Gazette, and at the same time invite interested persons to submit to him in writing, within a specific period, comments and representations in connection with the proposed notice. The provisions of paragraph A shall not apply if the Minister, in pursuance of comments and representations received, decides to publish the notice referred to in subsection 1 in an amended form. A notice under subsection 1 may be at any time be amended or withdrawn by like notice. A notice shall not be issued under subsection 1 or 3 unless the Minister for National Health and Welfare and the Council have been consulted. A notice issued or deemed to have been issued under Section 13 of the Machinery and Occupational Safety Act of 1983 and which was in force immediately prior to the commencement of this Act shall be deemed to have been issued under this section. What does this mean? Well, if there is a certain type of work that is threatened or potentially threatens the health and safety of employees, the government can place them into a specific category and state that they are no longer allowed to perform such works. Even the employer cannot force their employees to do any work that has been gazetted as prohibited or has been forbidden or banned. The Minister for National Health and Welfare, as well as the Council, must be consulted on when issuing a prohibition notice. Previous notices that have been issued under the previous Machinery and Occupational Safety Act of 1983 will still be enforced, and no draft will need to be required for these notices if they are amended. The only time that work can be done is if the Minister specifies how it can be carried out in the Gazette. This notice must first be made available as a draft for everyone to read and make comments on before it can become a requirement, unless it is released as an amendment to an original notice. Section 22. Sale of certain articles prohibited. Subject to the provisions of Section 10.4, if any requirement, including any health and safety standard, in respect of any article, substance, plant, machinery, or health and safety equipment, or for the use or application thereof has been prescribed, no person shall sell or market in any manner whatsoever such article, substance, plant, machinery, or health and safety equipment unless it complies with that requirement. Basically, there are requirements to follow for anything that any company does. Some companies will only need to use the OHS Act as a guide for what is needed, but others will need to see what legislation affects their work and abide by that requirement. Like we mentioned earlier about thinners in Section 10, the OHS Act does not specifically have any information on thinners, but in Section 2, it says that in addition to Section 10, if there is a requirement out there that affects your work, you must know it and follow it. So this means that all companies should have what we call a legal register. This is a register of what laws affect them and which part of the law is specific to their works. Let's give you an example. A plumber may have to work on a ladder. Now there is no specific section in this act that discusses ladders. And so one might want to use Section 8, duties of employers to keep you safe, or Section 14, duties of employees to try and create your own understanding of what should be done. But if we do more research, we will find that the General Safety Regulations, Section 6, work in elevated positions, as well as General Regulations Section 13A, ladders, helps us to identify what needs to be done. These would then be more specific on what to do. So they would be the requirements for the use of ladders over and above what the OHS Act requires. And if you were to do work on a construction site, then ladder work could fall under fall risk in the Construction Regulation 10. And now that section of that particular regulation will be in your legal register for the use of ladders. Section 23. Certain deductions prohibited. No employer shall, in respect of anything which he is in terms of this Act required to provide or to do in the interest of the health and safety of an employee, make any deduction from any employee's remuneration or require or permit any employee to make any payment to him or any other person. This means that employers are not allowed to charge employees for anything that is provided to protect them from harm. This would include things like training, personal protective equipment, fall protection, or anything that this Act or any other requirement has made mandatory for employers to do in the interest of health and safety toward their employees. Section 24. Report to inspectors regarding certain incidents. Each incident occurring at work or arising out of or in connection with the activities of persons at work or in connection with the use of plant or machinery in which or in consequence of which any person dies, becomes unconscious, suffers the loss of a limb or part of a limb, or is otherwise injured or becomes ill to such a degree that he is likely either to die or suffer a permanent physical defect, or likely to be unable for a period of at least 14 days either to work or to continue with the activity for which he was employed or is usually employed, a major incident occurred, or the health or safety of any person was endangered, and where a dangerous substance was spilled, the uncontrolled release of any substance under pressure took place, machinery or any part thereof fractured or failed, resulting in flying, falling, or uncontrolled moving objects, or machinery ran out of control, shall within the prescribed period and in the prescribed manner be reported to an inspector by the employer or the user of the plant or machinery concerned, as the case may be. In the event of an incident in which a person died or was injured to such an extent that he is likely to die or suffer the loss of a limb or part of a limb, no person shall without the consent of an inspector disturb the site at which the incident occurred or remove any article or substance involved in the incident therefrom, provided that such action may be taken as is necessary to prevent a further incident, to remove the injured or dead, or to rescue persons from danger. The provisions of subsection 1 and 2 shall not apply in respect of a traffic accident on a public road, an incident occurring in a private household, provided the householder forthwith reports the incident to the South African police, or any incident which is to be investigated under Section 12 of the Aviation Act of 1962. A member of the South African Police to whom an incident was reported in terms of subsection 3b shall forthwith notify an inspector thereof. When incidents or accidents happen, there are a few things that must be done. Two of these things are recording or recording and reporting. Recording. Any incident, regardless of its severity, should be recorded and kept as records for incident and accident management. This is a great tool to identify where risks are creeping through our safety management system. The second part is recording and reporting. Under Section 24, incidents and accidents, as they are called, are incidents or accidents that fit the criteria in this section of the Act. The Department of Labor requires companies to record these on an Annexure 1 form and report them using the correct reporting forms. Now, these may vary depending on who you have registered your COID or compensation with. We'll learn more about the entire compensation in General Administrative Regulations 9, Annexure 1 document, as well as the Department of Labor, FEM, RMA, COID forms in this course, which is Conduct an Investigation into Workplace Safety, Health and Environmental Incidents. But take note that records need to be kept for a period of at least 3 years. This is all based on the legislation found in the General Administrative Regulations Section 9 of the Occupational Health and Safety Act. Now, Section 24 states that certain incidents and accidents must be reported to the Department of Labor. These are incidents or accidents that arose from their work or even in connection with their work. So even if a person was not working with a power tool, but someone in the vicinity was, and the employee was injured by that power tool, it's still in connection with their work, and thus needs to be reported. Where any person dies, becomes unconscious, suffers the loss of a limb or part of a limb, or is injured or becomes ill to such a degree that they are likely either to die or to suffer a permanent physical defect, or even if they are unable to work for a period of at least 14 days, these must all be reported. They generally are reported by the employer or the user of the machinery. Other incidents that must also be reported to the Department of Labor are a major incident, or where the health and safety of any person was endangered. This is an interesting one, because the person was not actually injured. In this case, their health or safety was endangered. That means there was a high possibility for the person to have been seriously injured. These also need to be reported, so that even potentially harmful incidents or accidents can be investigated and hopefully mitigated. Then, where a dangerous substance was spilled, the uncontrolled release of any substance under pressure took place, machinery or any part of machinery fractured or failed, resulting in flying, falling, or uncontrolled moving objects, and lastly, where machinery ran out of control. Now, you may wonder, who must report these incidents or accidents to the Department of Labor? Well, they must be reported to an inspector by the employer or the user of the plant or machinery. So if you are an employee and were the user of the plant or machinery, you also have an obligation to ensure that the incident or accident is reported to the Department of Labor. When must these be reported? The above-mentioned incidents under Section 24A, B, and C should be reported immediately to the Provincial Director. It should be done by telephone, fax, or similar means of communication. They should also be reported to the Provincial Director within 7 days using the correct forms. If the injured person dies, the employer or user shall notify the provincial director of the death by fax or similar means of communication. The incident site may not be disturbed without the consent of an inspector in the case where a person dies, loses a limb or part of a limb, is likely either to die or be disabled. Action may be taken as is necessary to prevent a further incident, to remove the injured or dead, or to rescue persons from danger. However, this does not apply to traffic accidents on public roads, incidents at a private household, or accidents according to the Aviation Act. The investigation should be performed by one of the following persons: the employer or user of machinery, a person appointed by the employer to investigate the incident, the health and safety representative of the work area, a member of the Health and Safety Committee. The investigation should officially start within a period of 7 days and be finalized as soon as is reasonably practicable, or within the contracted period in the case of a contracted worker. An employer must ensure that the incident or record be examined by the Health and Safety Committee. Section 25. Report to Chief Inspector regarding occupational disease. Any medical practitioner who examines or treats a person for a disease described in the second schedule of the Workmen's Compensation Act of 1941, or any other disease which he believes arose out of that person's employment, shall within the prescribed period and in the prescribed manner report the case to a person's employer and to the Chief Inspector, and inform that person accordingly. This section is pretty self-explanatory. If there is a medical practitioner who examines or treats a person for a disease which he believes arose out of that person's employment, then that medical practitioner must within the specific period and in the correct manner report this case to the person's employer, to the Chief Inspector, as well as the person themselves. Section 26. Victimization forbidden. No employer shall dismiss an employee or reduce the rate of his remuneration or alter the terms or conditions of his employment to terms or conditions less favorable to him, or alter his position relative to other employees employed by that employer to his disadvantage, by reason of the fact or because he suspects or believes, whether or not the suspicion or belief is justified or correct, that the employee has given information to the minister or to any other person charged with the administration of a provision of this Act, which in terms of this Act he is required to give, or which relates to the terms, conditions, or circumstances of his employment, or to those of any other employee of his employer, or has complied with a lawful prohibition, requirement, request, or direction of an inspector, or has given evidence before a court of law or the industrial court, or has done anything which he may or is required to do in terms of this Act, or has refused to do anything which he is prohibited from doing in terms of this Act. No employer shall unfairly dismiss an employee or reduce the rate of his remuneration, or alter the terms or conditions of his employment to terms or conditions less favorable to him, or alter his position relative to other employees employed by that employer to his disadvantage, by reason of the information that the employer has obtained regarding the results contemplated in Section 12.2, or by reason of a report made to the employer in terms of Section 25. Victimization means the action of singling someone out for cruel or unjust treatment. Victimization is the process of being victimized or becoming a victim. If you refuse to work in an unsafe manner, you cannot be victimized based on the lawful obedience to the Occupational Health and Safety Act. Victimization may take many different forms. It could involve spreading malicious rumors about the employee, or insulting them or degrading them, overloading them with work, continually picking on them, swearing at the employee, using foul or vulgar or abusive language toward the employee, and so on. Whatever the case, it is unacceptable, and it is a violation of the human rights of the employee, and also a violation of the employee's right to be treated with dignity and respect. In fact, employers have a duty to protect their employees from harassment as opposed to subjecting employees to harassment. For instance, no person with HIV or AIDS shall be unfairly discriminated against with the employment relationship or within any employment policies or practices, including with regards to recruitment procedures, advertising and selection criteria, appointments and the appointment process, including job placement, job classification or grading, remuneration, employment benefits, and terms and conditions of employment, employee assistance programs, job assignments, the workplace and facilities, occupational health and safety, training and development, performance evaluation systems, promotion, transfer and demotion, disciplinary measures short of dismissal and termination of services. Section 27. Designation and functions of Chief Inspector. The Minister shall designate an officer serving in the department as Chief Inspector for the purpose of this Act. The Chief Inspector shall perform his functions subject to the control and supervision of the Director General of the Department, and may perform any function assigned to an inspector by this Act. The Chief Inspector may delegate any power conferred upon him by this Act, excluding a power referred to in Section 35(1), or delegated to him under Section 42, to any other officer, or authorize any such officer to perform any duty assigned to him by this Act. No delegation of a power under paragraph A shall prevent the exercise of such power by the Chief Inspector himself. Whenever the Chief Inspector is absent or unable to perform his functions as Chief Inspector, or whenever the designation of a Chief Inspector is pending, the Minister may designate any other officer serving in the department to act as Chief Inspector during the Chief Inspector's absence or incapacity, or until a Chief Inspector is designated. Any person who immediately prior to the commencement of this Act was designated as Chief Inspector under Section 19 of the Machinery and Occupational Safety Act of 1983 shall be deemed to have been designated as Chief Inspector under subsection 1 of this section. So this means that the Minister must appoint someone in the role of a Chief Inspector, so that the sections of this Act that require the enforcement can be carried out. The Chief Inspector is given duties and responsibilities that they must also adhere to. They need to be able to perform their functions correctly in terms of their appointment. This must be done under the control and supervision of the Director General of the Department. The Chief Inspector can also delegate the duties and functions they are responsible for to an inspector who must carry them out under the control and supervision of himself as Chief Inspector. The only thing a Chief Inspector cannot do is what is said under Section 35(1). In summary, if a person is aggrieved or feel that they have been unfairly treated by any decision or outcome of the investigation or inquiry, then they can submit an appeal, an application to a higher inspector for a decision to be reversed. This would be sent to the Chief Inspector, and they would then decide what to do based on the request, the evidence in the request, or any other information they feel is necessary. Even if the Chief Inspector delegates this power of authority to another person, such as an inspector, this does not mean that the Chief Inspector cannot still execute the powers given to him. That includes the power to carry out the duty the Chief Inspector has delegated to an inspector. If for any reason the Chief Inspector is not available to perform a function, then the Minister may delegate this function to another inspector until such a time that the Chief Inspector is available. If a Chief Inspector was appointed before the enactment of this Act, they still hold that appointment in terms of the previous Act, that is Section 19 of the Machinery and Occupational Safety Act. Section 28. Designation of Inspectors by Minister. The Minister may designate any person as an inspector. See Integration Regulations, Section 3, to perform, subject to the control and directions of the Chief Inspector, any or all of the functions assigned to an inspector by this Act. Each inspector designated under subsection 1 shall be furnished with a certificate signed by or on behalf of the Minister and stating that he has been designated as an inspector, provided that if his designation as inspector is limited to any particular function or functions, his certificate shall state such limitation. Whenever an inspector designated under subsection 1 performs a function under this Act, and in the presence of any person affected thereby, the inspector shall on demand by such person produce to him the certificate referred to in subsection 2. Any officer who immediately prior to the commencement of this Act was designated as an inspector under Section 20 of the Machinery and Occupational Safety Act of 1983 shall be deemed to have been designated as an inspector under subsection 1 of this section. So the Minister may assign the duty of inspector to any person they choose. The inspector will always perform their duties under the control and supervision of the Chief Inspector. The Minister must give the inspector a certificate showing that they have been appointed as an inspector, and if there are any items that the Minister does not want the inspector to do, or if there are any limits to the inspector's authority, it must be stated on the certificate. If the inspector who has been delegated such responsibility is carrying out his functions, the person who is affected by these functions being carried out may ask for the inspector's proof of certification as an inspector, and the inspector must show the certificate issued by the Minister to the person. If an inspector was appointed before the enactment of this Act, they still hold that appointment in terms of the previous Act, that is Section 20 of the Machinery and Occupational Safety Act. Section 29. Functions of Inspectors. An inspector may, for the purpose of this Act, without previous notice, at all reasonable times, enter any premises which are occupied or used by an employer, or on or in which an employee performs any work or any plant or machinery is used, or which he suspects to be such premises. Question any person who is or was on or in such premises, either alone or in the presence of another person, on any matter to which this Act relates. Require from any person who has control over or custody of a book, record, or other document on or in those premises, to produce to him forthwith, or at such time and place as may be determined by him, such book, record, or other document. Examine any such book, record, or other document, or make a copy thereof, or an extract therefrom. Require from such a person an explanation of any entry in such book, record, or other document. Inspect any article, substance, plant, or machinery which is or was on or in those premises, or any work performed on or in those premises, or any condition prevalent on or in those premises, or remove for examination or analysis any article, substance, plant, or machinery, or a part or sample thereof. Seize any such book, record, or other document, or any such article, substance, plant, or machinery, or a part or sample thereof, which in his opinion may serve as evidence at the trial of any person charged with an offence under this Act or the common law, provided that the employer or user of the article, substance, plant, or machinery concerned, as the case may be, may make copies of such book, record, or document before such seizure. Direct any employer, employee, or user, include any former employer, employee, or user, to appear before him at such time and place as may be determined by him, and question such employer, employee, or user either alone or in the presence of any other person on any matter to which this Act relates. Perform any other function as may be prescribed. An interpreter, a member of the South African Police, or any other assistant may, when required by an inspector, accompany him when he performs his functions under this Act. For the purpose of this Act, an inspector's assistant shall, while he acts under the instructions of an inspector, be deemed to be an inspector. When an inspector enters any premises under subsection 1, the employer occupying or using those premises, and each employee performing any work thereon or therein, and any user of plant or machinery thereon or therein, shall at all times provide such facilities as are reasonably required by the inspector to enable him and his assistant, if any, to perform effectively and safely his or their functions under this Act. When an inspector removes or seizes any article, substance, plant, machinery, book, record, or other document as contemplated in subsection 1, F or G, he shall issue a receipt to the owner or person in control thereof. This means that the Department of Labor inspectors may arrive on site to visit or investigate any company without prior notice, but at reasonable times. The visit must be to carry out their duty according to this Act. While on site, they may question any person, alone or in the presence of any other person, on matters of health and safety. They may examine any document or records that relate to the company's health and safety and question any person on the contents of these documents. They can also inspect the site, including any articles, equipment, plant, machinery, to determine if it is safe and without risk to employees on site. They may also seize any or the above documents, as we mentioned, any records, to be used by themselves and the Department of Labor to carry out their duties as prescribed by this Act, but will always give you a receipt of what was taken. If they want to speak to anyone who is not available at the time, they can arrange a date and time for that person to be available to meet with them and have a meeting. They will generally do this with a document stating the date and time. Digital means will also be used at times, mainly through email. Should they need assistance while visiting a site or attending a meeting, they are allowed to bring an approved assistant with them to the site or meeting. And everyone who is part of the company must give their full support to the inspector as well as those who accompany them, so that they may carry out their roles and responsibilities as per this Act. Section 30. Special Powers of Inspectors. Whenever an employer performs an act or requires or permits an act to be performed, or purposes to perform an act or to require or permit an act to be performed, which, in the opinion of the inspector, threatens or is likely to threaten the health and safety of any person, the inspector may in writing prohibit that employer from continuing or commencing with the performance of that act, or from requiring or permitting that act to be continued or commenced with, as the case may be. Whenever a user of plant or machinery uses or purposes to use any plant or machinery in a manner or in circumstances which, in the opinion of an inspector, threatens or is likely to threaten the health and safety of any person who works with such plant or machinery, or who is or may come within the vicinity thereof, the inspector may in writing prohibit that user from continuing or commencing with the use of such plant or machinery, or in that manner or in those circumstances, as the case may be. An inspector may in writing prohibit an employer from requiring or permitting an employee or any employee belonging to a category of employees specified in the prohibition to be exposed in the course of his employment for a longer period than a period specified in the prohibition to any article, substance, organism, or condition which, in the opinion of an inspector, threatens or is likely to threaten the health and safety of that employee or the employee belonging to that category of employees, as the case may be. A prohibition imposed under paragraph A, B, or C may at any time be revoked by an inspector in writing if arrangements to the satisfaction of the inspector have been made to dispose of the threat which gave rise to the imposition of the prohibition. In order to enforce a prohibition imposed under subsection 1A or B, an inspector may block, bar, barricade, or fence off that part of the workplace, plant, or machinery to which the prohibition applies, and no person shall interfere with or remove such blocking, bar, barricade, or fence. Whenever an inspector is of the opinion that the health or safety of any person at a workplace or in the course of his employment or in connection with the use of plant or machinery is threatened on account of the refusal or failure of an employer or user, as the case may be, to take reasonable steps in the interest of such person's health or safety, the inspector may in writing direct that employer or user to take such steps as are specified in the direction within a specified period. Whenever an inspector is of the opinion that an employer or a user has failed to comply with a provision of a regulation applicable to him, the inspector may in writing direct that employer or user to take within a period specified in the direction such steps as in the inspector's opinion are necessary to comply with the said provision and are specified in the direction. A period contemplated in subsection 3 or 4 may at any time be extended by an inspector by notice in writing to the person concerned. An employer shall forthwith bring the contents of a prohibition, direction, or notice under this section to the attention of the health and safety representatives and employees concerned. So this means that the Department of Labor inspectors have the power to stop any work that they feel threatens or is likely to threaten the health and safety of any person. This must be done in writing and will have a motivation on why this is the case. This may also be the case of works that require the use of plant or machinery. If employees are exposed to any article, substance, organism, or condition that threatens or is likely to threaten the health and safety of any person, the inspector may stop the employer from performing his work or allowing the employees to be exposed to it, or even restrict the amount of time allowable to be exposed to it. The inspector may even block off the entire risk altogether, maybe even closing off a section of the workplace that they feel threatens or is likely to threaten the health and safety of any person. If it is still possible to rectify the risks, then the inspector will issue a directive with instructions to follow to make sure that they act safely. An inspector can also extend a directive or prohibition for a duration they feel is in the best interests of the employees. After the written notice is given to the employer, and if the employer corrects the risks, then an inspector can remove the restriction. All of the above information relating to the health and safety of employees should always be given to the health and safety representative for them to know what is happening.